Good afternoon, everybody, and welcome to the Irish Women Lawyers Association of Ireland, our event, Paths to Precedent. And my name is Cleanna Kimber. I'm a senior counsel at the Bar of Ireland, and we have the very great pleasure today of having Anya Hines, Helen Noble, and Maura McAnally. Anya Hines and Helen Noble are both solicitors who were admitted to the Paths to Precedent last year, and congratulations to them. Maura McAnally is the chair of the Bar Council of Ireland and is a senior counsel at the Bar of Ireland of long standing, and she was also the recipient of the Irish Women Lawyers Association, co-recipient of the Irish Women Lawyer of the Year. So we have a very distinguished panel. So I'm absolutely delighted to have you all here. And I hope that there will be something for everybody today, whether you decide that you are going to go for Paths of Precedence and become a senior counsel, whether you're going to think about it this year, other years, or whether you're just going to evaluate your own career performance in a broader perspective. I think that this seminar will be of use to you. It is a taster seminar, so we will be able to have people speak for about 10 minutes and some questions at the end, and allowing you all to get a cup of coffee and back to another Zoom call or presentation at 2 o'clock. But as with all tasters, there's plenty behind the scenes, and all of the people that I have been speaking to on our panel are absolutely delighted, and I'm sure they'll say the same, to help anybody behind the scenes in person. So without further ado, I'm going to introduce our first speaker, Anya Hines. Anya Hines has been very active in the Dublin Solicitors Bar Association and on the Council of the Law Society. She is a solicitor at the St. John Solicitors, and her specialism is in mental health and capacity. So without further ado, I'm going to invite Anya to address you for about 10 minutes. Thank you very much, Anya.
Thank you very much, and thank you for inviting me. Thank you to the Irish Women's Lawyers Association for inviting myself and Helen here today. We're delighted to address you. So I have prepared a number of short slides. I'm now going to attempt to share those with you, which could be a challenge, and I hope I don't share anything else with you. Now, how is that? The slides have come up? Great. Success number one. That's far more challenging than the application form. No, I jest. The application form is, it's certainly a challenge. And what I'm going to highlight today is just the criteria for admission. And I am focusing on solicitors in particular in relation to this, because it is the first time that we have been entitled to apply for the title. And there are, I suppose, some unique challenges for solicitors in applying to become senior counsel, because traditionally, obviously, it's only been open to barristers, and there's been a focus on your litigation experience. And many solicitors, I think, consider that they're not actually eligible to become senior counsel because they don't have maybe litigation experience. So I just want to highlight that for solicitors, if I may. So I'm just going to rock on through the slides, because I know I'm limited in the time, and I don't want to eat into Helen's time or your question time. So now this technically is a challenge because it doesn't seem to be moving down for me. Just bear with me. Here we go, it is moving. So, and for those of you on the call today in this Zoom meeting, the next application deadline, I think, is the 5th of February. When myself and Helen applied in July of this year, I think the application process commenced with an advertisement in around the 3rd of July, and the deadline was the 24th of July. I spent at least a week pondering as to whether or not it would impact on my practice, because I wanted to ensure I wasn't being called to the inner bar and what impact it might have on my firm and my partnership. So I really spent a lot of time thinking about that. So I was checking through my emails today, and I see that I asked my referees if they would get on board on the 17th of July. So it was rather late in the day because of, I suppose, the constraints with the LSRA themselves. It is possible to get the information in the time if you obviously sit up till 4 o'clock in the morning every evening for a while. But you know, for anyone who may not have considered applying, there is this time around there is still time. So moving on then, just this gives some background as to the new process of applications for patent of precedence, and essentially it opened the door for solicitors to become senior counsel. The committee who decide on whether or not you're suitable to become senior counsel is a fairly august body of persons, including Chief Justice and the Presidents of Court of Appeal and the High Court, the Attorney General, Chairperson of the Bar, President of the Law Society, and a lay member nominated by the Minister. So the committee met to establish the criteria to be met by a legal practitioner, and by virtue of the fact that all legal practitioners could now apply, that's a practicing barrister, qualified barrister, practicing solicitor. This became the route by which solicitors could now apply for a patent of precedence to use the title of senior counsel. And just to be clear, up until obviously this year, it was only open to barristers to apply, but now solicitors could apply, and I've set out the closing dates there, and we were notified of the recommendations in the 1st of September. And again, just to clarify, and this was what I wanted to clarify before I applied, was that regarding a barrister, it entitles him or her to be called to the inner bar and to use the title senior counsel. And regarding a solicitor, it entitles him or her to use the title of senior counsel. So it doesn't mean that you're called to the inner bar and you can't continue in your practice as a solicitor. Then in terms of the criteria, and this is what has to be addressed in the application form, and this is the focus of anybody who's going to apply, you have to have displayed as a legal practitioner a degree of competence and a degree of probity appropriate to and consistent with the grant of a patent. You have to show professional independence, and so I think everybody can meet those criteria. And then in addition to that, you have to meet one or more of the following, and this is important, I think, for solicitors. You have to have a proven capacity, either one or more of the following: a proven capacity for excellence in the practice of advocacy, a proven capacity for excellence in the practice of specialist litigation, or a specialist knowledge of an area of law. And I know some people who were successful as in this round as solicitor senior counsel wrote in advance to the LSRA and in terms of the application process, and clarified that it wasn't necessary to show a number of cases, for example, that you've had reported cases, or to show that you had litigation experience in particular. So we have people like Paul Egan, who's a company law expert, and he would not have had a significant amount of recent litigation cases, but of course his expertise in company law has been recognised by him achieving a patent of precedence. You also then have to be suitable on grounds of character and temperament, and be in possession of a tax clearance certificate, and be otherwise suitable to be granted a patent. In terms of you have to meet the highest standards, and you have to have a professional experience, legal knowledge and probity, and you have to have a depth of professional experience and perspective acquired over a considerable period. You have to have up-to-date and expert legal knowledge, and you always have to behave with probity. You have to show professional independence, and you show your duty to the court. And I think that's something that we all have to show in our careers in any event as lawyers. You have to have integrity, honesty, and professional standing. And I suppose notably as well, you have to create and maintain productive working relationships with clients, colleagues, and the judiciary. And you have to, again, going back to the 3 criteria, demonstrate ability in one or more of these criteria. The form is extremely helpful if you go through the form and the explanatory guide that goes with it in terms of how you can demonstrate and give examples of each of these areas. And that's the way I approach the form. You're going to be assessed and you have to give compelling evidence of excellence. And then otherwise suitable, which I think is useful for those of us who have applied, and those of you who may wish to apply, is to consider the exhaustive list of matters the committee may deem to render an applicant suitable and maintaining in the legal profession for the good administration of justice, and a significant contribution to Irish society as a legal practitioner. So for those of you who are on committees and wonder about your commitments and trying to align those commitments to your work commitments, if you're thinking of applying for senior counsel, I think I certainly put in examples of the committee involvement that I had, and involvement with the Law Society Council, and involvement with the DSBA as its president. So they're all very useful things, which I didn't anticipate ever that they would become part of an application for senior counsel, but it does pay off. And you have to have 2 referees as well, one of whom has to be a judge at any level and one from a legal practitioner. I mentioned at the start that I only contacted my referees on the 17th of July, and they were very gracious in turning around the references for me very quickly. I think it's important that your referees, who will know you in person perhaps, may not be familiar with all of your work and your cases, etc., that they would have some sight of your application form to assist them in relation to the reference that they're going to provide, and also to let them know the criteria under which you might be scored and marked. And I just wanted to, I suppose, given that I'm here today for the Irish Women's Lawyers Association, and sometimes and I've seen some of the statistics, and I think it was Elizabeth Fitzgerald, I think, that was looking through some of the statistics, and it is disappointing that not a huge amount of women applied in comparison to men, and also we weren't as successful as our male colleagues. And I think we have to look at that, and we have to consider, how do we take credit for the work that we do, and how do we acknowledge and recognize our own contributions? And sometimes I think we're a little bit reticent, a bit shy about being able to talk positively about ourselves. I had the great advantage of having applied for state tenders over the years, and despite my reluctance, I had to give myself credit where credit was due. And I think we all need to do that. And I'm confident that I did a good application, and I did showcase my work well, because I've had that experience. So I encourage you all to not be shy, to, if you're applying, to really go for it. And women belong in all the places where decisions are made, and it shouldn't be that women are the exception. So I'll finish on that. I'm going to stop sharing my screen if I can.
Thank you very much, Anya. That was absolutely wonderful. And when Anya and I chatted before this, Anya really did tell me that she had the experience of putting together tenders was absolutely invaluable in that she was able to target very clearly what was required and put it in a very succinct and concentrated manner. And I think that's one of the themes that we'll see when we're talking to everybody. It's about really being proud, unabashedly and unashamedly proud of our achievements and putting those down in writing. So the next person then that I'm going to call on is Helen Noble. And Helen Noble is in her own firm, Noble Shipping Law. And if I have the name correct, and Helen, you might correct me if that's not correct. And Helen has an unusual specialization of maritime law. And I think Helen is going to give us a sort of a personal view as to the whole process, why she went in particular to take up the patent of Precedent, what benefit it has to her and the application process. So thank you very much indeed, Helen.
Thank you, and thanks to the Irish Women Lawyers Association for having me here today. It's a real pleasure. It's great for Anya and myself to actually talk about our achievement, particularly in circumstances where I suppose it's not been subdued.
Anya, I think we're having a little difficulty in hearing you. I wonder if maybe you can put your sound up a little bit.
Yep, hang on 2 seconds. Better?
That's much better, yeah.
There we go. That's my daughter. It's her laptop and she's turned the mic down for online teaching.
That's one of our all of our ongoing difficulties, isn't it? Trying to manage this in the COVID. So thank you very much.
Anyway, I was just saying, I think for myself and Anya, perhaps the achievement and the recognition has to some extent been, I wouldn't say subdued, because I wouldn't say it's been subdued, but quieter, I suppose, with the COVID. And this is a great opportunity to share our experience. So thank you for inviting me here today. I'm really glad that Anya has produced those slides and talked about the application process, the content of the process. I suppose just picking up a few points on the application process itself. I think Anya's correct. You know, it's never too late to apply. From my own personal experience, the application form is a challenging form because it really takes you from the beginning of your career through your career history, and it's quite a thought-provoking process. It follows a very logical format, but it does require you to think about all that you do, and then to put that succinctly into words. And again, picking up on a point that Anya made, I think women on the whole are more reticent to blow their own trumpet, and certainly this application process made me think long and hard about lots of things that I had done throughout my career and continue to do, that perhaps I wouldn't normally sing about or talk about in any respect, but I realized doing the application for myself, the worth of some of the things that I was involved in. The application process perhaps for me was, to some extent, I wonder whether it was slightly easier because I come from a practice which is quite unique. There was a lot for me to talk about in terms of my maritime experience, and I fitted very succinctly and into the sort of the niche category of a specialist area of law. And that's really, I suppose that's what prompted me to make the application, because I knew I had 26 years plus experience in maritime law. So when I first heard about the application for a patent, it kind of sang out to me that was, oh, this was perhaps made for myself. But as I say, I think we are reticent and as women. And so the application form, I think, even if you decide not to go through with it this year, or you decide to wait a few years, I think it's actually worth looking at the application form and thinking what you would say about yourself, because it really does challenge you to admit all that you do. And Anya, I can see you smiling, you probably agree with that. But so the application form itself follows, as I say, a natural progression. So it takes you through your career history, it takes you through explaining what you have done in terms of cases, how they have been applicable to your practice of law. It then takes you through to you as a person, what you've done in terms of contribution to your particular area of law. And it really makes you think about how in practice you've contributed to that area. So I think it's a fantastic process, even if you don't decide to go ahead with it, or even if you're not successful. I kind of urge you all to look at it, because it's worth considering all the great things you do. From a personal perspective, I just wanted to give you sort of an insight into what it's meant for me in terms of my practice, because I think one of the questions that I was asked by quite a lot of people is, oh, that's all very nice, lovely, yes, you're in the first group of solicitors to be granted the patents. Why did you do it? Why did you need to do it? And you probably would have seen quite a lot of chat on Twitter, for example, of wondering why we were applying. Was this just sort of for our own egos, perhaps? And from a personal point of view and how it has impacted my own practice, most of my clients would be large shipping companies or insurance companies based overseas, who have commented since I was granted the patents that it's a recognition to them that they are appointing a specialist in that area of law in Ireland. And so it has meant to them not the immediate fear, oh gosh, we're going to be charged an awful lot more money by this woman now she's got a couple of initials after her name, but more, okay, we're in safe pair of hands. And I think for that, it's important. It is a recognition of our seniority in our field of law, or a recognition of our seniority in terms of years of practice and dedication to what we all do. And certainly my clients, that's the feedback I've got back from them. Great, we're delighted to see we've got the right person, we're in the right hands, and that's important. I suppose the other thing from a personal perspective is the application form itself made me think for a considerable period of time, who are the appropriate people to ask to be referees. And again, just to pick up on a point of Anya here, there would be, for example, plenty of judges that I would have appeared in front of with counsel over the years since my time here in Ireland. But you need, I think, to think carefully about someone who can give you a reference that knows you personally, or certainly knows your work personally. Now, again, that might have been easier for me because there would be a limited pool of judges or legal practitioners in the field of maritime law. So I didn't have to fish very hard to find the suitable referee. But I think you do need to think about who that person is, and that person needs to know you and understand you, because I think the references are a critical part of the application process. And just to finish up and to echo again, Anya, please do think about applying. Obviously, the statistics showed that there was perhaps not many women applying, and those that did, the success rate wasn't as high as our male colleagues. I think the reason for that is twofold. One, as I said, we are reticent, but secondly, I think we would question more, what do we need this for? What's the purpose of it? And I just would like to say, I think it's worth doing. It certainly has been a journey for myself, a journey I'm proud of, and the application process is not simple. It's not straightforward. I think for myself and Anya, we were the first year as solicitors applying and perhaps had less support to call on as to what you would put in the form. You know, I know, Clona and Maura, you would probably have views on this, but I would imagine at the bar, there is more people you could have spoken to when making your application to get an understanding of what each section of the form was looking for. Anya and myself were probably rowing a boat on our own on this one to begin at this stage, but I'd like to certainly offer anyone who's thinking about applying, please pick up the phone and talk to me. And in time, I'm be delighted to give you more insight as to what a particular section of the form is looking for. I can only tell you what I thought it was relevant, but I think it would be useful, and the offer's there if anyone wants it.
Thank you very much indeed. That's extremely generous, Helen. And as I say, I had a fantastic conversation yesterday with Anya and with Helen, and you're really just getting a tip of the iceberg from everybody. I would echo, I think, what Helen has said about the form. It is very long, and it's quite a self-evaluating. It took me several weeks, and you had to put in your publications at the end, and copies of them in hard copy. And as I had written a couple of books, I couldn't put those in, obviously. So you have to try and think, well, how am I going to put forward what I do with, you know, and adapt the form to my own practice? And everybody will have their own questions about that. But there is a lot of reflection. What was my role? What did I do? And what did I bring to it? And what is my role in this particular piece of work? So thank you very much indeed. That was really fantastic, Helen. And now I'm going to invite Maura McAnally. And I'm delighted everybody is well within time. So that does lead to some questions. And if people are a little bit reluctant to put questions up, I have a number of questions that we talked about yesterday, and I'll go back over those with all three of the speakers. So Maura, if I can invite you then to.
Thank you very much. And thank you for the invitation today. And just Helen, I'm just going to follow up on that point about discussing with colleagues. The curiosity is that here at the bar, the application for your patents of precedence and to become senior counsel or a member of the inner bar, it's something that people down here don't advertise. You would only really discuss it with your closest friend or possibly with your mentor and ask that person for some advice, but it's certainly not discussed in general. And the reason is that there's a difference for barristers versus solicitors. And by this, I mean the only progression for people at the bar in respect of advancement was you were junior counsel, and then the only next step within your career and profession was to become a senior counsel. And for a barrister to do that, it means you are literally going from being a reasonably big frog in the pond, where you had sufficient expertise, sufficient work behind you, and you are now going to start as a senior counsel, a member of the inner bar, but you were starting off as a tadpole again. So you had literally spent 20, 25 years of your life building up your career and your work base as a junior counsel. And you were then taking this leap of faith, not necessarily being guaranteed that those solicitors who had had faith in you as a member of the junior bar would carry that faith forward and instruct you as a member of the inner bar and a senior counsel. So based with that wall of fear, people down here tend not to discuss it. And in fact, we had a webinar recently in respect of the application, and we ensured that people could join the webinar on an anonymous basis, because people don't want others to know, because there's a fear that the solicitor who instructs you, or the insurance company, or whoever the client is, might say, oh, but sure, we won't brief Maura now as a junior counsel in January. Sure, she'll be gone off as senior counsel in October and November, and that's a different panel altogether. So we won't brief her. So you could end up in a situation where you have no work from the minute word gets out that you've applied, with no guarantee that your application is going to be successful, and then find yourself becoming senior counsel. And then becoming senior counsel and member of the inner bar for barristers is, as I say, a leap of faith, because you are literally never going, unless you're doing crime, you go back to do criminal trials, but in your capacity as senior counsel, an entirely different capacity. But for me, I don't do crime, I only do civil work. It meant I have not been back to the circuit court since I took Silk. You literally hand all of your work back and you start again, as I say, as the tadpole in the pond. And one of the reasons behind the application form, looking to your experience, at least from a barrister's perspective, is that you're able to show that you have had sufficient amount of experience and practice and cases in litigation behind you. And in the old forms, before the LSRA, it was presumed that some of that would then carry forward with you and follow you in your practice as a senior counsel. But that doesn't always come to pass, because if you do civil work, insurance companies have panels. So you may have been good enough to be on their junior panel, but it doesn't automatically mean you're going to be, in their eyes, good enough to be on their senior counsel panel. Similarly, so for all other bodies and organizations out there that operate panels, it's not just an automatic. So for members of the bar, it is a huge leap of faith. And Anya, you talked about the form, the applications had to be in last July. Last January, or is it last January? No, it was last December and November, I wrote to the LSRA and I apprised them of the fact that from a barrister's perspective, having a closing date in July is ridiculous, because for barristers, it's entirely different. We have to rearrange our entire practice. So you need to get the forms in early. And then the hope is that you'll get an answer back earlier, hopefully by May or June, but they haven't decided yet when the answer will be given to people as to whether their application has been successful. But for example, when I applied for Silk and to be a member of the inner bar, it was a time of flux in government. So basically we weren't told until July, and we were one of the latest bunch of applicants ever. So between July and literally the 30th of September, you're running around trying to organize your practice, to send papers back, make sure people take on those cases, to organize your wardrobe, because literally you go from wearing the uniform of a junior counsel, which is just your tabs and your black gown. You now have to organize your uniform of a senior barrister. So you have to have your waistcoat, your long tails, and you have to have your silk gown. And you can't just walk into Arnott's or anywhere like that and just pick it off the peg. They invariably have to measure you. And as I found out, it takes a little while, not just for them to measure you, but to get it put together. They can't just do it in a week. It takes a little longer than that. And then you have to sort out insurance and things of that nature. So from the perspective of the Bar of Ireland, there are differences and there are huge alterations in your practice that have to be attended to. And hopefully this year, everybody will get an answer sooner instead of having to wait until July, the end of July, to find out, have you been successful or not? So that's one of the difference from the perspective of a barrister versus a solicitor. In respect of the application itself, Anya has gone through the form. Helen has mentioned references and the repercussions for solicitors when they are successful. But all I would say to people when you are sending in your form and when you are looking to referees, you need to consider who the people are who are on the panel who are going to be reading those references. So personally, and this is my personal opinion, not as the chair of the Bar of Ireland, personally, I think that when a reference goes in front of somebody and they recognize the name of that referee, I think they accept 110% what's being said. So I presume from the Bar of Ireland's perspective, that's also slightly different because there are only 2,200 of us. Whereas for solicitors, I'm not sure of the figures, whether it's
20,000 on the roll. 20,000 on the roll.
Oh my God, I was going to say 12, 13,000. So
no, 12,000 with practicing certs, but 20,000 on the roll.
So you have 12,000 practicing solicitors. And can you imagine a judge or the Attorney General, Chief Justice, President of the High Court trying to recognize every name? It's not easy for them to do that. It's easier when they're dealing with barristers who are standing on their hind legs in front of them arguing almost every day of the week, or at least we were in the good old days. pre-COVID-19. But it does help to have a recognized name when it comes to a referee. That's the only thing that I would say. And then in respect of the Act itself, it's section 170, and it does provide for a difference, which is we apply under section 170A in relation to a barrister, a patent of precedence, the grant of which to the barrister entitles him or her. Notice they put him first, not her. Entitles him or her to be called to the inner bar and to use the title of senior counsel. And B, in relation to a solicitor, a patent of precedent, the grant of which to a solicitor entitles him or her to use the title of senior counsel. So basically our application is to a degree in respect of two issues. We become not only senior counsel, but members of the inner bar, and we get our patents of precedence. And as I say, we need the time in order to rearrange our practices and then launch ourselves as tadpoles into the pond again. In respect of the form itself, it used to be that you had to recite all of your cases that were reported in the Irish reports. So for any practitioner out there, barrister or solicitor, who feels that they are not in litigation and not in front of the High Court or the Court of Appeal, or as it was back then, just the High Court and Supreme Court, I spent weeks scouring the Irish reports, trying to find my name mentioned in a good light somewhere in those reports. And the reality is the work that I was doing, which was civil work, I was at least 3 days or 2 days on circuit and maybe a day or two in the High Court, but a lot of the cases settled, a lot of the cases weren't reported. I had to go back 10 years before the date of my application to find some of my planning cases so that I could put one of those planning cases in. I then had to find what on circuit is equity, chancery and non-jury, some of the building contract cases I was in, to put those in, and then trying to find seminal, which are quite hard to do in the personal injury sphere, trying to find seminal cases in respect of personal injury. But I was in the envious position, and I have to admit I was very lucky, I was in the envious position that I had appeared literally in front of all of the persons who were reviewing the application from a judiciary perspective. And when it came to my own application, it now says a member of the judiciary and a senior practitioner. I had actually asked 2 High Court judges for a reference, and following the old rule of thumb, which was considered the mannerly thing to do, I had also approached the Circuit Court judge on the Midland Circuit, which was where I practiced most, and had asked her firstly to apprise her of the fact I was applying as a matter of courtesy, and asking her as well for her support. So I literally had 3 references at the time. But to go back to the whole issue of the application for patents of precedence and women becoming a senior counsel or senior counsel and members of the inner bar, from our perspective, without going over the old ground, we all know that the first women called to the bar were Avril Deverell and Frances Kyle 100 years ago, November 1921. It'll be 100 years ago this year. But the first practicing senior counsel, member of the inner bar, Silk, was Mella Carroll. The first practicing female senior counsel was in 1977. It's hard to think that it's taken that long for there to be more than one. And she was the one and only practicing female Silk in the country. And then 2 years later went on to become chair of the Bar of Ireland. But I find statistics and facts like that mind-boggling. But I'm glad that it has been opened up, that women are more towards advancing themselves. We are definitely equal. We are as good a decision makers as any man. We are as good an advocate, whether it be oral advocacy or written advocacy. And as was stated earlier, we just simply have to have faith in ourselves. Men seem to be born and bred with a gene called huge faith in themselves. They just believe that they are capable of everything and anything. Whether they are or not is a different existential question. And that would take me many, many hours to discuss that. But we need to have faith in ourselves. We need to believe we can do it. When I was applying, I put it off, I would say, for at least 4 years, if not 5 years, based upon the fear factor. Will they brief me? Will they brief me? It's not like the old adage, build it and they will come, because that's not necessarily so. And particularly for barristers, because as I say, you go from one practice that you've built up and had for 20, 25 years, and you start again. So it is a leap of faith. But if you have faith in yourself, then it makes that leap of faith easier, obviously. But believe you can do it. And once you answer all the questions in the form and show your area of expertise, show your capability as a written advocate and an oral advocate, show that you have an area of speciality, show that you are specialized in an area of law. And then on the proviso that you have the appropriate references and your tax clearance certificate, it should be no bar. So I hope I haven't spoken for too long, and I hope that that has addressed.
Thank you, Maura.
So I'm not sure where you want to go from here, Cliona, sorry.
Yeah, it should be no bar, pun intended.
Wasn't sure.
No pun intended. Getting these messages, your network is low. Listen, thank you very much, Maura. Again, I think from listening to all three people, I think what's come across, and we do have a few questions, and thankfully we have some time now for questions, but I think what's coming across from Maura, Anya and Helen really is the need to be confident and to be happy enough to, we debated what we might call this, whether it's blow your own trumpet or sing your own praise, and to be happy to put that down in writing. And in my work in employment equality, I've been in cases where I've seen studies and analysis of application forms done by external consultants on application processes. And time again, they would give examples of the same type of activity, but the male might say, I led a team to do that, and the female might say, I was part of a team. So a lot of it is, and in these application forms is how you describe what you have done and how you put it forward in a fairly positive manner. So that's why I hope that even for people who aren't applying for patents and precedents, that this webinar today may help you for applying for other things as well. So let's just go to our.
We've lost you there, Cliona. Maybe if you switched off your video, then we'll get your voice back.
Is, and I think as a solicitor practitioner of taking patent precedents.
I think we missed your question there.
Yeah, apologies. I'll go and say that again. The question there is, could we ask Anya to comment? If Anya can see the chat there. As to the point made by Helen as to what she saw as the value to her as a solicitor practitioner.
Well, I suppose, first of all, I saw that the opportunity was open for solicitors to become senior counsel, and that just was a challenge, and I really felt, why not? I don't want to be flippant about it and compare myself to Mallory climbing Everest for the first time, or trying to climb Everest, but you do it in a sense because the challenge is there and it's open to solicitors to do it. And we're, I felt, and I want to emphasize that I applied on the basis of a specialism as well, and that's in mental health and capacity law. And I've really worked very, very hard in that area of law. And I felt, I could be entitled to have patent of precedence, which says that I have demonstrated excellence in my profession and in my work. So part of it is personal to me, that I felt this was something I would like to go for and to apply for and to achieve. And maybe that's a competitive part of me, I don't know, but. And then in terms of value, like Helen, my clients are comforted by the fact that not only was I telling them that, look, I've done a lot of work in this area of law, but there's external recognition by an august body, as I said, the committee, that I have achieved a level of excellence. So that gives my clients comfort. And clearly I work for, a lot of state bodies now as well, and I think it is useful in the tendering process. So for all of those reasons.
Thank you.